A routine court hearing suddenly took an unexpected turn. The judge warned that missing court could lead to bond forfeiture. Every decision made inside the courtroom carried serious consequences for the people involved.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive on this case. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. And Mr. Couch, you were previously in court, entered a plea of guilty to driving while intoxicated, third or more. There was initially an agreement of probation. We were here last week. You guys discussed it and you went with your attorney, Mr. Wilkerson, and discussed and changed your mind and wanted me to agree and follow a recommendation of 3 years in prison. Is that correct? Were you arrested for anything between last week and this week?
No.
All right, then at this time, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you, sir. See, Mr. Gertz, you've got Miguel Martinez. I show that's set for a plea. Is that correct?
Not really, Judge. Got a couple of discovery issues with the cross preparation for everything.
Okay.
I think we may need to talk about
Miguel Martinez.
Oh, we may need to go off the YouTube as well, not off the records, but off the.
I'm sorry, I missed on that.
Cedric Brown. This is so dark though.
The lights out.
Good morning. Are you Cedric Brown? And Mr. Brown, did you get someone hired?
No, I had looked into a couple lawyers. James Mackin, he was trying to charge 5,000. Then I had Stovall, Gallon.
Mm-hmm.
Then I had Brittany Holmes.
Okay.
I had talked to those, but I think I'm probably gonna end up going with James Mackin because he was the cheapest.
All right. And you think you'll be able to save up and get that done if I give you a little more time?
Yes, ma'am.
So thank you for doing what I asked, Mr. Brown. What I'm going to do is reset your case another 30 days to see if you can get Mr. Macon hired or someone else. Again, get that reset today, bring it to him if you hire him. If you're unable to hire him, contact at least 3 others, see if there's someone else. If not, bring me those names and then we'll discuss your options. All right, step in front of the clerk. Good morning, you're Richard Montalvo. And Mr. Montalvo, were you able to get someone hired?
No, ma'am. But I did call quite a few lawyers. It's just trying to get the funds to do that. So
And are you working?
no, ma'am.
Okay, why aren't you working?
I had brain surgery 8 months ago, and I
Okay.
still have a fractured shoulder. So
Okay,
I can't get. They won't release me, and I'm probably gonna have surgery on it. So it's just kind of.
so, all right, so thank you for doing what I asked you to do, Mr. Montalvo. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed
Yes.
lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct.
Yes, ma'am.
You step in front of the clerk on the end, she'll give that to you. So we still don't have anything on the panel. I don't need to call the name though, I guess. Well, I mean, I don't want let's just do a short reset, and then if the bondsman doesn't get that information, then I'll forfeit it, and then I'll maybe push that to happen. Damian Hurd. Good morning. Are you Damian Hurd?
Yes, ma'am.
And Mr. Hurd, this is your initial appearance and cause number 26 DCCR 0050. You're charged with the 3rd-degree felony offense of tampering or fabricating with physical evidence from November 21st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am. I went and talked to Marvin Lewis, and he told me that he might not be able to represent me. That was the court appointment I
What-
had.
so- Right, so here's what happens is when you're in custody, we automatically give you a court-appointed lawyer. Mr. Lewis is your attorney. But now that you've bonded out, I expect you to try to hire your own lawyer.
Yes.
So what I'm gonna do is reset your case for about 30 days. Give you some time to see if you can get someone hired. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you your reset notice. Good morning, you're Casey Kincaid. And Mr. Kincaid, did you get someone hired?
Let's go, I get him, Kevin, I am like names, but I might go with the names like sometimes.
Where are you working, Mr. Kincaid?
Work for the board.
Okay. And you're actively working right now? Okay. I want you to make sure you stay in touch with your bondsman. I've got an email here from Miss Caesar. So it looks like she was maybe the,
Yes.
that she signed off on your bail, on your bond. Make sure you talk to your bondsman because at least according to this, it looks like she might not want to be that third party person anymore. So you need to make sure you have somebody or take that care of that yourself.
I have somebody, we supposed to go to the bondsman first and take care of it.
Perfect.
My bondsman already know.
Okay. It's also important if there's some issues going on between you and her, just stay.
Let's not separate.
Okay. That can be emotional and it can cause some issues. You already have some issues here, so make sure you don't let any of that cause you to do anything that you shouldn't do. Go to work, get you a lawyer, and then go home and take care of your bondsman as well. So what I'm gonna do is reset your case to give you a little more time to see if you can get someone hired. If you do, bring the reset notice. If you don't, talk to at least 3 others. You can see they all charge at different amounts and have payment plans that are different. Bring me those names and then we'll discuss your options. Okay, step in front of the clerk. That's cause numbers 26 DCCR 0989 and 0990. Let's see what the bonds are. I'm gonna raise the bonds in each of those cases, or forfeit the bonds in each of those cases for non-appearance. I'm going to raise them in each case to 150,000.
No response, Your Honor.
And the defense bond will be forfeited and for non-appearance and reset at 100,000. Travis Hingston. Good morning, sir. You're Travis Hingston.
Yes.
And Mr. Hingston, did you get someone hired?
I asked the question on and I've Campbell, it's just a little too high right now.
Are you working?
Yes, ma'am.
Where do you work?
JP Fulfillment Warehouse.
Okay. If you want, I can have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer, or I can give you one more reset to see if you can hire someone. I don't, with your income, I'll just have to take a look at it to see if you qualify, but if you want to fill out that paperwork, I'll let you.
I understand, so I might be trying to hire.
All right, well, you've been coming a few times now, so you need to try to get him hired before that next court date. If you get Mr. Adams hired, bring the reset notice to him. If for some reason you're not going to be able to, talk to some other attorneys, also bring a pay stub and we'll get you to fill out that paperwork next time. All right, step in front of the clerk. Terrence Jenkins. Good morning, you're Terrence Jenkins?
Yes.
And Mr. Jenkins, did you get someone hired?
Several people, so Williams Law Firm said they're charging 10,000. Walker Law Firm to me is charging 15,000. Franklin said they're charging 10,000, like I'm saying 500 Frank, and so get a Parker side of 2,500.
So,
I'm not working right now. The job I was supposed to get, my background didn't go through, so I couldn't get hired. I'm waiting on the HR to call me from my old job to see if I'm eligible to be hired for the charges.
I'm gonna have you, thank you for doing what I asked you to do, Mr. Jenkins. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. You step in front of the clerk on the end, she'll give you that paperwork. Good morning. Are you David LeBlanc?
Yes.
And Mr. LeBlanc, this is your initial appearance. Can you hear me?
Yes.
This is your initial appearance in cause number 26 DCCR 0644. You're charged with a third-degree felony offense of theft of property, and that's from July 21st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I've just talked to my lawyer Friday.
Okay, who's that?
Raquel.
Okay, and you're going to hire him on this case?
Yes, ma'am.
So what I'm going to do is reset your case about 30 days to give you some time to get Mr. Kimler hired. If you do get him hired, make sure you bring the reset notice that you get today to his office and they'll tell you what to do. If that's not going to work out for some reason, then you need to talk to at least 3 other attorneys before that next court date and bring me those names so that I know you're trying. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you a reset notice.
Good morning.
Good morning. You're Kyle Whittington. And Mr. Whittington, you're here in both, in 2 cases. Did you get someone hired?
Sunny Eckert was the one we're actually shooting for still, but like I started off with this new job, like this hot shop business, and it takes a little bit of money to actually like start it up. So like I've had to put a lot of money aside so I can get the money I really need to actually be able to hire them. So like it's gonna take a little bit more. I can go for like, public defender right now, but I may probably replace them eventually with Sunny Eckert.
You're working now?
Yeah, like I'm doing hot shots, like I'm basically running trucks, like across Texas, like loads and stuff like that, and I get paid like by the basis, like weekly.
All right, so I'm going to reset your case one more time. This is going to be the last reset. You need to try to get Mr. Eckert or someone hired before that next court date. If it's not going to work out with him, then make sure you talk to some others, bring me those names, and bring me any information you have with regard to income as well. If you don't get somebody hired. Step in front of the clerk, she'll give you a reset notice.
Thank you much.
Sentencing, Mr. Nichols, Ms. Holmes is stepping in for, okay. Tina, Mr. Gertz?
Is this talk before them? Is this? Did you taking this one? He just kind of.
Is he keeping it?
He's keeping it.
No, okay.
All I can say.
Well, is he gonna be here this morning? All right, you're Jesus Medina, and this is 26 DCCR 0778. Mr. Medina is charged with intoxication, manslaughter, and what is the announcement?
But we're asking for more time on this. There's lots of discovery and experts and various things. So this is a complicated, maybe even more than normal, finding more complications of complicated cases.
Right, any issue that you see? All right, so we'll just do normal reset, see where we get. Mr. Medina, make sure you stay in touch with Mr. Gertz so you can start going over whatever information he has, and we'll see where we are at the next court date. All right, you're free to go. Leandre Simi, Mr. Gertz?
This way I see, I had an email from him, he lives out of state.
Okay,
He's on his way out.
if you'll
We
just,
expect him to be here.
you'll call the name Leandre Simi, Seam. I mean, I'll do the forfeiture, but nothing will happen if he gets here. We'll recover.
He sent me an email saying I'm on my way. I'll see you there.
I would like to speak with Judge Nolan. About it.
On the public perception.
Judge,
Yes.
Mr. Douglas from the initial setting is in the jury box.
Okay, thanks. Mr. Jeffries, you got Morris Williams?
Yes, Your Honor.
Good morning.
Good morning.
Morris Williams?
He's not going to be answering.
He's not. Okay.
I spoke with Ms. Malvino about this, and the particular issue today is vehicular, but there's kind of a grander issue at play that we're trying to get sorted out, which may very well have contributed to the issue that we're seeing today. We were just gonna ask for a reset in order to have that.
And I'll have to forfeit his bond.
Then we would ask that you wouldn't.
His bond will be forfeited for non-appearance and reset at 100,000. If he gets in touch with his bondsman or has some specific information, more so than what you know at this point, let me know. Obviously, if somebody's having vehicle problems and can't get here, I'll be somewhat reasonable, but I need a little more information.
Yes,
All right, thanks.
thank you.
Tommy, what's his name?
Douglas, last name Douglas. Douglas. Tyler Douglas. Tyler Douglas.
All right, Mr. Douglas, come up, please. That's right. It's very important that you're here on time, Mr. Douglas. And you are Tyler Douglas. I'm going to recall the bond forfeiture. Mr. Douglas, this is your initial appearance. And cause number 26 DCCR 0905. You're charged with a second-degree felony offensive burglary of a habitation, and that's from April 3rd of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Are you working?
I do go odd jobs, but it's just me and I take care of my wife and she's had a stroke. So I take care of both of us. She's paralyzed on the right side. You know, it didn't help.
What? I'm sorry. I can't hear you.
Just on the right side, but I don't get any help, so I'm doing it.
All right, I'm gonna have you fill out some paperwork this morning, Mr. Douglas, to see if you qualify for a court-appointed lawyer. It's important that you fill it out accurately and completely because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk on the end, she'll give you that paperwork.
Thank you, man.
Mr. Lewis, you've got Brissa De Hoyos.
Just, I haven't seen it this morning.
Brissa De Hoyos. Nobody, we've got lots of people, nobody wants to see us today. July 4th was Saturday. Everybody's had a day to cover. The bond will be forfeited for non-appearance and reset at 100,000. You get in touch with her. If she shows up, just let me know. Akaya Nash.
He's outside.
For a minute, I felt like I heard the baby crying. I thought it was coming from. Oh, yeah. And good morning. Are you Akaya Nash?
Yes, ma'am.
And this is 26 DCCR 0206. Ms. Nash is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I spoke with Ms. Nash and who's to stay in this situation. We've gotten an offer on it. There's an alternative offer there as well. So I just need a little time to talk to Ms. Nash to see what's going to be which option she wants to proceed with.
All right, we'll just do one more reset. Ms. Nash, it's important that you make an appointment, go visit with Mr. Lewis before that next court date. So y'all can go over all of your options and we'll get an announcement of what you want to do at the next court date, okay?
Yes, ma'am.
All right. Good morning, sir. You are Charles Toussaint.
Yes, ma'am.
This is cause number 26 DCCR 0527. Mr. Toussaint's charged with unlawful possession of a firearm by felon. And what is the announcement?
Judge, Mr. Toussaint has provided me some medical records that I need to, one, fully review myself because it would definitely have a definite impact on whatever was offered or whatever would be in this case. Well, I've let Mr. Smith know that, so if I just get a little time to review that myself and just talk with him.
All right, any issues, Mr. Smith? All right, sir, I'm going to reset your case about 30 days or so. Make sure you call Mr. Lewis, get in touch with him. Y'all visit before that next court date so we can get an announcement at the next court date.
Okay.
All right, you're free to go, sir. You can go back out that same way. Yeah.
Yeah, I'm talking to you outside. I'll be a friend.
See, Mr. Kimler and Mr. Nichols on Raquel Glover. That should be a pattern now. Yeah, thank you. All right, so you're Raquel Glover, and this is cause number 24 DCCR 0232. Mr. Glover's case was set for trial a couple of weeks ago we were about to start with jury selection. Mr. Kimmler filed a motion to quash the indictment based on some relatively new cases that have come down from the Fifth Circuit as well now from the Supreme Court with regard to underlying offenses on unlawful possession of a firearm by a felon. I have done a substantial amount of reading of those cases and reviewing all of that since the last court date. I know your position, obviously, Mr. Kimmler, Mr. Nichols, what is the state's position?
Judge, after looking at those myself, I think we're in the Fifth Circuit case dealt with the underlying felony of being a simple possession of drugs. The Supreme Court ruling wasn't so much felon possession of firearm, but a firearm in the possession of a firearm by a drug user. So that was kind of the main theme under all those cases was simple possession, simple drug use does not equal dangerousness. In this instance, Mr. Glover's prior is for child endangerment. And while it is some years ago, on its face, that is reasonable to deduce that's a dangerous prior felony. He also has the intervening felon possession of a firearm in the years since that original conviction. So I think in this instance, the state can make a very clear argument that he's shown a history of dangerousness and that the prohibition on possessing a firearm by a felon should apply and the motion of quash should be denied.
All right, thank you. Anything else to follow up?
Other than just, I think the inquiry is dangerousness, and obviously drug cases are a subset of dangerousness, lack of dangerousness, but I don't think the ruling is limited simply to drug cases. I think the court's research probably reflects that. The question is whether the underlying felony conviction of endangering a child rises to that level of dangerousness so as to preclude his ownership of firearms or possession of firearms. I would just note that at the time he pled to that, there was no DWI child passenger statute. And I think had that statute been available, that's probably what he would have pled to. And then you obviously wouldn't have the endangering language and the conviction itself. So that is something that I would ask the court just to note that should the case just not to take notice of the fact that if the case were indicted today, it probably would not have been pled as an endangering child, DWI child passenger, and whether DWI child passenger cases are inherently dangerous, I guess is another inquiry as well.
So there's nothing at this time in these newer line of cases that is specific with regard to any other real underlying type of offense other than possession of a controlled substance or possession of a drug of some sort. And I'm not going to start going down the road, I think, of making those decisions unless it is real clear. I think for whatever reason that underlying offense should not be included. And so I am going to deny the motion to quash, and we will get this case set back on the trial docket as quickly as we possibly can.
I think it's currently, it has a trial.
Is it still already? Okay, it is. All right. And just also part of that finding that I'm making is based on the actual facts of the underlying case, regardless of whether or not it's an endangering a child or nowadays a driving while intoxicated with a child passenger. I would think regardless, it's the same, that the facts of this case as reviewed with a young, I think it was a 9-month-old or 8-month-old sitting in the lap of the passenger in the front seat of the car. I think that in and of itself is dangerous, whether it's a DWI or an endangering a child, either way. So that is the basis of my findings. So we will move forward with trial at that next court date.
Sure.
All right.
Thank you.
You can, you're free to go, sir. I don't have an order. If someone would prepare an order, please.
Yes.
Himmler, someone. And then you have Jacordian Guillory, 2 cases.
Yeah.
Good morning. Are you Jacordian Guillory?
Yes, ma'am.
And Mr. Guillory has 2 cases. 23 DCCR 1225 is a motion to revoke probation. Underlying offense is evading arrest or detention with the use of a vehicle. And then we've got 26 DCCR 0631, a new offense of evading arrest or detention with the use of a vehicle. And what is the announcement?
Your Honor, I've reviewed the discovery in this case and discussed it with Mr. Guillory. He's advised that he did not commit the new offense, although the state's conveyed what I consider to be a reasonable offer to dispose of the NTRP in the new case. Since Mr. Guillory is maintaining that he's innocent in the new charge, I have to set it for hearing.
So I would,
Absolutely not true.
so we want to go through the motion then and go forward on that motion instead of the, let me get that pulled up. And are there any videos or anything that you need some time to watch?
No, I don't think
before?
for reading the file, there were some videos that identify the defendant. Or actually identify the person operating the motor vehicle.
Oh, okay. All right. Give me just a second to get that pulled up.
I do have some media on that, Judge, and I'll make sure that Mr. Kimler, if he indicates to the court that he is retained on that case, I will make sure he has access to discovery and I'll make a copy of that.
I've got them on both cases.
Okay.
So if you'll make that request, Mr. Kimler, it sounds like there might be something that,
And also, Judge, at the appropriate time, if I might just ask the court some questions regarding the bond issues, I'd appreciate that.
Mr. Guillory, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down, and will he waive the formal reading of the motion?
You will.
All right, Mr. Guillory, in clause number 23, DCCR 1225, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest or detention with the use of a vehicle, February 27th of 2026. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
Not true, because
It's okay. I'll get the explanations later. I just need to know true or not true.
yes,
Count 3 alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, February 7th of 2026. And is that true or not true? Count 4 alleges that you failed to provide and maintain an accurate residence address with probation officer. It says you reported your address at 2218 Rush Street, but identified your address at 2450 West Lucas to the Beaumont Police. Is that true or not true?
that's not true.
Most people think missing court by a few minutes isn't a big deal. This judge completely disagreed. During this hearing, the defendant arrived after his case had already been called. The judge immediately explained that when someone fails to appear on time, the court can forfeit their bond and issue a warrant for their arrest. Fortunately for this defendant, he had stayed in contact with his bonding company while trying to get to court, and the judge decided to recall the bond forfeiture. But the warning was unmistakable. Court schedules matter, and arriving late can instantly create much bigger legal problems than the original criminal charge. The hearing then turned to the felony charge itself, assault on a peace officer. The judge asked whether the defendant had been able to hire an attorney since bonding out of jail. The defendant explained that losing his freedom had also caused financial hardship. He had recently lost his job, making it difficult to afford private legal representation. Rather than immediately appointing an attorney or pushing the case forward, the judge gave him another opportunity. She postponed the case for about 30 days, giving him time to continue searching for legal counsel. But this wasn't an unlimited extension. The judge ordered him to meet with at least 3 different attorneys, compare payment plans, and return to court with the names of every lawyer he contacted. She wanted proof that he had genuinely tried to hire someone before asking the court for additional help. Before ending the hearing, the judge delivered one final warning. If the defendant returned to court without making those efforts, she could raise his bond and send him back to jail for failing to follow a direct court order. It was a reminder that judges expect defendants to actively participate in their own defense rather than simply waiting for the court to solve every problem. Here's today's question. Imagine pleading guilty to forgery, knowing your future now rests entirely in the hands of a judge. That's exactly what happened in this courtroom. The defendant stood before the bench, accused of forging a financial instrument worth thousands of dollars. Before accepting the guilty plea, the judge carefully questioned him to make sure he fully understood the consequences of what he was doing. The defendant admitted that he had reviewed every document with his attorney, understood the plea agreement, and was pleading guilty voluntarily because he had actually committed the crime. The judge also reminded him that by accepting the plea agreement, he would be giving up his right to appeal the case later. It was a serious moment because once the plea was entered, there would be no turning back. The agreement itself offered the defendant an opportunity many people never received. Instead of sending him directly to prison, prosecutors agreed to recommend 5 years of deferred probation. That meant if he successfully completed probation, he could avoid a final felony conviction. But there was one major issue still unresolved. No one could agree on exactly how much money had been lost. The indictment listed one amount, while prosecutors argued the actual restitution exceeded $8,000. Rather than rushing to judgment, the judge decided the court needed accurate financial records before imposing sentence. He explained that restitution isn't simply a number written on paper. It must accurately reflect the victim's actual financial loss. If the parties couldn't agree, the court would hold another hearing to determine the correct amount. Instead of sentencing the defendant that day, the judge ordered a pre-sentence investigation. He explained that probation officers would interview the defendant. A guilty plea doesn't always mean the case is over. Sometimes it's only the beginning. In this courtroom, a defendant admitted to violating a protective order, a felony offense that can carry serious consequences. Before accepting the plea, the judge carefully reviewed every constitutional right the defendant was giving up. She confirmed that he understood the plea agreement, had discussed everything with his attorney, and was entering the plea voluntarily. In exchange, prosecutors agreed to recommend 5 years of deferred probation, along with a $1,000 fine. But before moving towards sentencing, the judge focused on something she considered even more important than punishment: the safety of the protected person. The judge learned that the defendant and the protected party shared children together. That created a difficult situation because parents often need to communicate about custody, school, and medical appointments. Even so, the judge made one thing perfectly clear. There could be absolutely no direct contact. No phone calls, no text messages, no in-person conversations. If information about the children needed to be exchanged, it had to happen through a trusted third party, another family member, an attorney, or the family court system. The judge even recommended using a parenting communication app where every message would be permanently recorded. That way, neither side could later claim conversations happened that never actually occurred. It was practical advice designed to reduce conflict while protecting everyone involved. Before ending the hearing, the judge ordered a pre-sentence investigation so probation officers could learn more about the defendant before sentencing. She instructed him to meet with probation immediately after leaving the courtroom and reminded him that following the no-contact order was now one of the most important conditions of his release. One mistake could completely change the outcome of the case.
Because I had to change.
All right. Did you tell probation?
Yes, ma'am.
Okay. Count 5 alleges that you failed to provide documentation verifying the source and amount of your income, 2025 tax returns, etc. Is that true or not true?
That's true.
Count 6 alleges that you failed to provide verification of performing community service hours as required. Is that true or not true?
Not true.
Count 7 alleges that you were at a location other than your residence at approximately 11:20 p.m. on February 27th of 2026 in violation of your curfew. Is that true or not true?
Was bad.
February 27th of 2026.
It's not true.
True.
Okay. Count 8 alleges that you are behind in your court assessed fees as of April 20th of 2026 in the amount of $1,812. Is that true or not true? All right, did you enter your pleas of true to counts 3, 5, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 3, 5, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke the probation, but I'm not going to do that. I'm going to reset the case for a hearing. And any discovery or any issues with regard to that new case get taken care of before then. And Ms. Malfino, do you anticipate that being, I guess, just one officer?
One officer and Miss Lopez.
All right, so we can just do it at 11, don't y'all
Yes.
think? No, just on a regular court date, but at 11, giving us about an hour. Okay. All right, we'll see you back then and we'll get an updated pre-sentence report as well. All right. We need a fingerprint over here, please. Oh, wait, is there something else? I'm sorry.
No,
Come
I
back.
just was gonna let you know, I actually have one of those officers coming for a motion to suppress next week. I don't know if that will give Mr.
That's fine. We can do it
time,
then.
but I'd be happy to do it. It's next Monday, the 13th at 1. We have a couple of those type of hearings.
That's fine.
I don't know that I can get an updated,
Okay, I just wanted to offer.
okay,
Same officer would be here.
it would be, okay, as the 1 o'clock. Let me look at that and make a notation on that and I'll take a look at it after I look at it. You can? Okay, thank you. So we'll see. Monday at, I guess, 2:30.
That'd be great.
But if y'all need to, if you need to see anything or watch anything before then, maybe get here early, but if not, that's fine.
Written discovery, they didn't identify the driver.
Make sure he knows, tell him 2 o'clock,
2 o'clock. man.
2 o'clock Monday,
2 o'clock.
next Monday at 2 o'clock. Mr. Burbank, you've got Jalen Eli. Okay, I'll hold it. Thank you. And then what about Robert Griffin, Mr. Burbank?
He's vacationing in federal custody in LaSalle, and my understanding that once that is taken care of, this case will be dispositive. So.
Correct.
The bonds will get the email for that. They get filed.
Do at large with that. All right, I'm going in cause number 26 DCCR 0764. Find that Mr. Griffin is at large without proper bond. Raise his bond in that case to 150,000.
Judge, will the court please note on that, we also pulled the co-defendant Lamb, LAMB, over from CDC on that, just FYI.
Oh, okay.
Todrick Lamb.
Is he also in
Not that I'm,
federal custody?
not that I'm aware of.
Okay. Morning. Are you Jalen Eli?
Yes, sir.
And will your client waive the formal reading of the indictment?
I do want.
Mr. Eli, in cause number 25 DCCR 1004, you're charged with a state jail felony offense of forgery of a financial instrument from April 8th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? Yes. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for a 5-year deferred probation. There would not be a fine. There would be restitution that would be determined between now and when we come back for sentencing. Is that your understanding?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objecting state's one.
It's admitted. Is there any evidence that Mr. Eli is not competent?
No.
And I guess
I have the restitution
It's,
now.
is it the amount on the indictment of that check, $4,471?
No, no, it is not, Judge.
It's different.
Yes.
Do y'all want to go?
Not by
ahead?
much. I mean, it's 8,132.88. And the only thing I would advise the court is that he has 3 pending, it looks like misdemeanors in Furio County that are not disposed of, to my knowledge. The defendant may know better than those.
Do you want to agree to that $8,000 amount, or y'all don't agree to that amount? Okay, so I'm going to, say number 1 is admitted, and then I'm going to find, Mr. Eli, that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so we can get a pre-sentence report done, get that restitution amount figured out from their side. And then if there's some objection to that, if we need to have a small hearing, we can do so at that time. On your way out of the courtroom today, you need to stop and talk to probation. Is she sitting at that desk right over there?
Yes.
Okay, we'll see you back at sentencing.
Excuse me.
Yes, sir. Thank you.
Get a reset. Check over it.
Ms. Holmes and Mr. Paget, that's it. Ms. Holmes on Kenneth Cormier, are you ready?
Yes, we've taken care of him, just finished taking care of him.
Okay, so that's gonna get taken care of here. All right, thank you.
Mhm.
He's free to go.
Okay, thank you.
All right, so now we're just waiting on, I think, Mr. Paget to complete his 2. Mr. Garrick, we called your name this morning. You weren't here. What happens when you're not here on time is your bond gets forfeited and there's a warrant for your arrest. It's very important that you get here on time.
Yes, ma'am. I kept in contact with the bond people while I was on the way here.
Okay.
Entirely.
Okay, so I'm gonna recall that bond forfeiture, and this is your initial appearance, Mr. Garrick, in cause number 26 DCCR 0961. You are charged with the 2nd-degree felony offense of assault on a peace officer from March 12th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am, but I also have been having situations like since me being locked up, it stopped a lot of like money problems, so it kind of like was an
Are
issue.
you working?
Yes, ma'am, right. Currently, I start my job this week, but
So here's what I'm gonna do, Mr. Garrick. Now, once you bond out, I expect you to at least try to hire your own lawyer.
yes,
So I'm gonna reset your case for about 30 days to give you some time just to see if you can get someone hired.
yes, ma'am.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what you need to do.
Yes, ma'am.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you a reset notice. Did you have something else? Did you have something else?
Seems here now.
Oh, yeah.
Is over in. And you have a specific ask about
The
this.
small pheno on scene, since you're here. Right. Somebody. It's obviously it will now be probably the oldest case on my docket, so it's very likely that it would be number 1, and we'll know that on the pretrial date.
And my request would be, again, I know this is an unusual request, but obviously it's very expensive and time consuming to come in for a pretrial. So my request would be to just note, I don't know that there would be pretrial issues other than getting trial order. So if he could appear via Zoom or appear, I don't, let me appear on his behalf or something like that for pretrial. And again, normally I don't ask for special dispensation, but he's a Haitian refugee. He's not a loaded with money person, and it takes a lot of energy and effort and costs and days of his life to come here and then go back. And so.
I mean, and I will do my best on that. Obviously, the concern isn't just about him either. So it is going to have a pretrial. Miss Malfino, if you'll get with Mr. Katina and whoever is going to take care of that case, we'll put it on the trial docket. And if you will just send over some request in writing, a memo or something to myself, Mr. Katina, and Miss Malfino, so that I will remember that when it gets a little closer to that pretrial. And then I wouldn't think there would be any objection. Okay, so we'll allow him, unless something comes up that obviously we need him here for some pretrial hearing, we can do that by Zoom for him. Okay?
I appreciate it.
All
Thank you,
right,
Judge.
free to go. Mr. Paget?
Thank you.
Yep.
Things worked out better down the hall.
I was a little worried.
It's okay. I'll never leave you hanging. I'll walk out of there before I do that.
No.
No, yes, I will. I would rather be here all day.
Thank you.
Leave it at
All
that.
right, sir, are you Darius Jack?
Yes.
You speak up.
Oh, look, you did two of these.
Nerd, I had you the wrong one.
Well, they both say,
No, I did too. That's just how good I am.
there you go.
I know, actually, we did one last time.
Because that date is, yeah,
And I needed to work something out in Hardin County, so.
got it.
That's
Okay,
done.
and will Mr. Jack waive the formal reading of the indictment?
You will, Your Honor.
Mr. Jack, in clause number 25, DCCR 1624, you're charged with a third-degree felony offense of violation of a bond or protective order within 2 times within 12 months from on or about September 24th of 2025 through October 4th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes.
Do you fully understand them?
I have to go through them again.
You want
So-
copies of them, but.
Sure. Is there anything about those documents that you signed that you know right now that you don't understand? So do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. You understand? Also, and it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objections to states 1, Your Honor.
It's admitted. Is there any evidence that Mr. Jacks is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. So the underlying, it looks like there was a protected party of a Lillian Ortiz, which is the issue underlying. I want to make sure you understand, Mr. Jack, that as of now, a condition of your bond, if it wasn't already, it should have been, is that you have no contact or communication with Lillian Ortiz. Do you understand?
Yes, ma'am.
Do y'all have children together?
Yeah.
Okay.
Yes, ma'am.
Yes, ma'am.
So any switch of children or talking about children needs to go through a third party, a parent, a brother, a sister, or through the family court with attorneys. All right. Does that make sense? So you can't go in person, pick up and drop off kids. You need to have someone do that for you.
Yes, ma'am.
That is very important. You can't call, you can't text. You need to have someone else do that for you. There's also some great programs and apps that you can get on your phone. One's called the Family Wizard. I would be absolutely encouraging of you to do that. Y'all both get that app, and every communication you have is saved on that app. So she can't say he was doing all this or he said blah, blah, blah. And you then can talk about kids have a doctor's appointment or kids have a soccer game or whatever it is. But it has to be an approved app, and you can talk to probation about that when they do that pre-sentence report. Make sense? All right.
Good thing is they worked all that out. There has been they have no reason to contact each other, the way
Perfect.
things are set up now. So,
Sounds good.
but I appreciate the admonishment.
All right, so talk to stop and talk to probation on your way out of the courtroom today. She'll get that process started for the PSI, and we'll see you back at sentencing.
Yeah.
All right, pretty good, sir.
Thank you.
Daniel Martinez. Good morning. Are you Daniel Martinez?
Yes.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
And are we going on count one only?
That's my understanding, Your Honor.
Give me a second to get a. All right, Mr. Martinez, in cause number 25, DCCR 1414, the state has elected to proceed on the count one only. It alleges you committed the second-degree felony offense of aggravated assault with a deadly weapon from August 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes, sir.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes, sir.
Do you fully understand them?
Yes, sir.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, sir.
And it looks like the agreement is for a 6-year deferred probation. There would be a $1,000 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objections to states 1, Your Honor.
It's admitted. Is there any evidence that Mr. Martinez is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right over there.
Yes, sir.
All right, we'll see you back at sentencing.
May I be excused, Your Honor?
Yes, sir. They should be getting them out. Anything that we need to take up before? Yes,
There are a couple of things, Judge.
okay.
In addition to the motion in limine, which is just a boilerplate standard motion.
Have you had an opportunity to look at the state's motion in limine?
I did, Judge. The only thing I have question on is that the state has complied with 3914 in reference to criminal histories or any other problems from the witnesses. Because I have not been provided any in one of their limine requests.
The state is not aware of any such information, with the exception of this weekend. I was made aware by our executive assistant, district attorney Brett Featherston, that he called me and told me that a Mary Chapman, who is on our witness list, and I intend to call her, officer with BPD, is under some form of administrative review or something's being something to that effect about an incident involving her investigation of a crash in which an individual involved in that crash was taking cell phone photos, because we're not being broadcast off.
Yeah, we are. Right, I don't understand, I think what you are mentioning on their motion in limine. Are you talking about other witnesses?
Mention of any past crimes, wrongs, or any of this act with convictions or character of any of the state's witnesses. And I believe it's number 4, Judge. And Just wanted to make sure that,
Okay.
because I haven't been provided anything.
Is there anything that you know of that you have not?
Not that I'm aware of.
Then there wouldn't be anything. Okay. Any others?
And just that they've provided everything they have in reference to the defendant. Reference to any prior bad acts or anything like that they have in their possession.
We filed a notice of extraneous offenses.
See that.
That to the that's all we, in the way of bad acts, prior bad acts that we intend to introduce, unless we become aware of something during the course of the.
Okay, so I'm going to grant the state's motion in limine in full. If there's anything obviously that comes up, Mr. Burbank or Mr. Coleman, that makes either of you think that any of these things on the motion in limine would become admissible or relevant, just approach outside the hearing of the jury and we'll take care of it at that time.
There is another issue, Judge, an ID tech with Beaumont PD lifted a latent print or prints from the suspect vehicle. Those prints are referenced in a report done by the that ID tech, which was turned over to defense counsel in discovery. And in that report, it indicates that there was a quote unquote APHIS hit on those latent prints that linked back to this defendant. While it was referenced in the report, just this weekend when I was prepping the case, I realized I didn't have those latent prints and I didn't have the APHIS report. So I reached out by email this weekend. The ID tech emailed me the actual prints referenced in the report, and I have forwarded that email to Mr. Burbank.
Okay.
But nevertheless, they were referenced in the report.
Okay. All right, anything else?
There is surveillance video in this case, Your Honor, about 30 minutes, allegedly about 30 minutes before the incident, in which this defendant is seen leaving the probation department. He was scheduled to meet with his probation officer on that day, about 30 minutes before the shooting incident. He is, at least the state's position is, he's captured on surveillance video walking into and out of the probation department wearing the similar clothing described by our victim and leaving in a similar vehicle. I think it is important, certainly we want to put that surveillance video in. There is no identifying or markings on that video that would indicate quote unquote probation department or CSCD. However, I think it's important to establish that the individual by the name of Asa Jones had an appointment at the probation department that day. I am perfectly okay with not referring to it as probation department. I'm not going to elicit the employment of any sponsoring witness for that video. Like, you work for the probation department. What I wanted to say is, and I'm open to suggestions, is a government entity or agency in downtown Beaumont. He had an appointment there. This is video from that government entity. That's my proposal on how to handle it.
I would think for identity, that would be relevant. It sounds like, Mr. Burbank, thoughts on what terminology would be,
My understanding is they're gonna put a probation officer up there. I mean,
well, I mean, it is what it is. They've got, I mean, I would think if you want to, you don't have to necessarily ask exactly what agency they work for. Do you work for, a Jefferson County government agency? And then, we don't have to get into what she does or he or anything like that. You work for an agency, it's downtown Beaumont. Did this person have an appointment? And nobody goes into, I mean, obviously, if you cross-examine.
yeah, I don't know whether or not you even have to get into that. If they're going to sponsor the video saying that this was video from where I work, or not where I work, but I'm the author of this video, and that's it. You say you had an appointment, it doesn't take a rocket scientist to put two and two together. But if you say, this is a video of.
Well, but I would think the point of it would be that it was they would be testifying that person with the same name had the appointment.
Well,
not just the video.
Does it have to be an appointment? It's just that we looked at our video, we were requested to look at, I'm, the keeper of the video, it all works well. And upon a request, we got that. This is fair and accurately depicting on such and such a time or such and such a date. I mean, they can't, if they're going to say that's him in the video, then I think that opens up. Okay, well, how did you know? just a strange person, but if he's just gonna post the video and say that this was.
But if that person can identify, can the person?
No,
identify?
I will admit that video is not the best quality, which is
Okay,
why we would like to go into the records maintained in the ordinary course of business by the agency, by the entity that would reflect that this person with this name had that appointment that day.
so it's, you're going to get further. I think it would be relevant. And depending on what comes out, probably admissible for identification purposes if that person from the probation office, that we're not going to say probation office, is allowed to say that this person.
Well, he just said he didn't know the person.
No, but he's saying that they have records from the department that say that Asa Jones had an appointment that day at that agency. And I don't see how that's not relevant. If just based on what little I've heard about, this is clothes and identifying factors, and here we have the defendant with this name, and I think it's admissible. I think it's just a matter of tiptoeing around what the agency is, and what, you don't have to say what the appointment was for or anything like that, but that he had an appointment at this agency, and I'm going to allow them to testify that.
I mean, it's this person that's going to testify or knows or has personal knowledge that he was seeing her or him at the agency.
It sounds like the testimony is just that he had an appointment that day.
Yeah.
Is that person knowledgeable in reference to the appointments that day, or is she just reading, or he just reading off a record?
As a business record custodian.
Yeah. Okay.
For the record, I objected this time, Judge, and I asked that you rule on it, that it opens up extraneous. In addition to that, well, I think I filed an objections for any of the business record.
He filed an objection, but I don't know that this is the type of, I mean, if it was provided 14 days ahead, then I don't know. It's not like the certificate of analysis where.
Showing an objection to the cell phone records.
I
Specific action. Oh, I see another objection to 911 call business record affidavit.
But I guess my question is just if a business record affidavit is filed timely, 14 days ahead of trial, unlike a certificate of analysis, where if there's an objection, then you have to bring the witness. On a business record affidavit, I think if it's filed timely, what is the objection?
I think the only objection, I'm sorry, Mr. Burbank, is to the form. It's to the form of the business record. So, or some defect in the business record.
Yeah, I think it's just as to the form. I looked it up and I don't see anything that says if it's something's objected to, then it has to be, if there's a specific part of the form. I'll take a look at, I looked at one already and it looked, I mean, these are from April. So obviously they're, well, at least one of them is, and then the other is.
Judge, the 911 call, we're going to bring a live witness to sponsor that.
So we don't have to worry about that one, but then the other one is,
cell phone records, business record.
and that was done also, it looks like it also in early April.
Yes.
Okay, unless there's an objection, at the time to the form of the affidavit, then, that will be overruled. I'm going to also overrule the objection with regard at this time to, a witness from the probation coming and testifying. I will, I think Mr. Coleman understands, and I want everybody to understand, I am going to limit that to everyone only questioning, not mentioning probation department, not mentioning community supervisions, nothing like that. Just had an appointment. It's a governmental agency, had an appointment. Here's the video, the keeper of the video, the keeper of the records that can say there was an appointment. And then unless there's some questioning on cross that opens the door further, then obviously I would just be very careful with that, Mr. Burbank.
Reference to, I have to ask, is he now going to put documentation in as the business record?
I don't plan on doing that, Judge. Just a video, but not as far as.
So testimony of the appointment and the video. correct?
Yes, Judge.
Okay. So, obviously, if you feel like something else has been opened after any of that, make an objection as it's happening, and we'll take it, outside the presence of the jury and go from there.
One last thing, I've provided Mr. Burbank with redactions. I don't know if I mentioned that, timestamps for the redactions made to the video in anticipation of objections by defense counsel, Judge.
So what I'm gonna ask, Mr. Burbank, for that, if you'd need to go over that, this evening or tomorrow morning early, so that if there's any objections, I want to know ahead of time so that I can watch the video before we get started tomorrow.
I'm well aware of this court because in appeals that I have written, there have been several attorneys and I represent to the court. I think I sent an email to the learned state counsel last week and I got them just now 5 minutes ago.
That's fine.
But
Just
I will take care of it.
take a look at it this evening, tomorrow morning, whenever you have an opportunity, so that if it's something that I have to watch.
Yeah, there's just one thing. There was a interrogation or it brought him in. You're not doing anything.
No, Judge, he invoked his right to
Yeah,
counsel about a minute into that
You
video.
or
Okay.
they talked for about 40 minutes afterwards, but I wanted to make sure that.
And I'm not,
Okay.
yeah.
So the one that you are planning on offering is a video of what then?
Body worn camera.
Oh, okay.
I've redacted the 911 call, in that 911 call had 2 additional unrelated calls on that same recording.
Okay.
And then there's a couple of other videos as well that I've redacted sound only. I don't know exactly what they are because I referenced them by their file names and the file names are pretty lengthy.
Okay.
I think they were both body worn cameras as well.
Okay, just take a look. If y'all have any issues, just let me know in the morning. All right, anything else? Mr. Vasquez, Mr. Smith, Mr. Lewis, you guys are all free to go. Thank y'all very much. Mr. Nichols.
When Tyler Douglas stepped forward, the case became more personal. He explained that he cared for his wife after her stroke while trying to survive on odd jobs. Now the court had to decide what would happen next.